Order.
All right, and now we have the sound on. It's going to be an interesting morning. Are there any other introductions that need to be made before we move on? Okay. Confluence Rivers, would you please go ahead and start your portion of the presentation?
Thank you, Your Honor. As you may be aware, this case represents the first rate case for Confluence Rivers since its acquisition of 9 water systems and 9 sewer systems as a result of the Commission's order in file number WM-2018-0116. The closings on the water and sewer systems took place between May and July of 2019. As closings took place as to the various systems, tariffs for systems already regulated by the Commission were adopted by Confluence Rivers, and tariff sheets were filed associated with the previously unregulated systems. The existing rates of each system were adopted by Confluence Rivers. Since acquiring these systems, Confluence Rivers has made improvements to each of the systems. The cost of the improvements completed as of today is approximately $2.9 million. Confluence Rivers, again, as of today, has approximately 547 water customers and 636 sewer customers spread among the various water and sewer systems. Confluence Rivers has implemented customer service that provides benefits to the customers. This includes 24-hour emergency service phone lines for potential service issues, on-call emergency service contractor personnel, implementation of a computerized maintenance management system for wastewater and drinking water utility assets, real-time remote monitoring to ensure service stability, customer dissemination of Missouri Department of Natural Resource drinking water testing information, online bill pay options, up-to-date website bulletins about current service status, and service initiation and discontinuance procedures. The rate case for both the water and sewer services provided by Confluence Rivers were initiated through the staff-assisted rate case process by notice delivered to the Commission on August 29th of 2019. The parties were ultimately able to reach a unanimous disposition agreement in this case, which was filed on February 10th of 2020. That agreement calls for a revenue requirement increase as to water rates and sewer rates that is less than what was initially proposed by Confluence Rivers. Additionally, the disposition agreement calls for consolidated water and sewer tariffs that will bring all water customers and sewer customers under a common set of rules and regulations. You may have noted that in the disposition agreement that the acceptance of the new water and new sewer tariff books will result in the cancellation of 11 sets of tariff sheets that currently exist today. The tariffs will also utilize a consolidated water rate and consolidated sewer rate for these customers. Each of these systems is, on its own, extremely small in terms of customer numbers, and each has had varying levels of record keeping and upkeep over the years. Consolidating the systems for rate design purposes allows the costs to be spread over a greater number of customers and will provide a more stable rate for customers over time for what is a similar service from system to system. Confluence Rivers filed the tariffs that had been attached to the disposition agreement on March the 13th of 2020. These tariff sheets carried a proposed effective date of April 12th of 2020. The tariffs, again, that were filed are the same tariff sheets that were attached to the disposition agreement. Confluence Rivers asked the Commission to approve the unanimous disposition agreement and allow the filed tariff sheets to go into effect. Thank you, Your Honor.
Thank you. We'll go to staff next. I'm sorry, let's pause here. Do we have any questions from the bench? I know that we have commissioners on the line. Okay.
From me.
Thank you. We'll go ahead and move on to staff's presentation.
Staff would agree with what the company has presented. It would note that the improvements that have been made, the money that's been spent on those is about 15% complete in consideration of all of the improvements proposed to be made for these systems. And it would also note that we conducted a full investigation and an audit of the books, and what is reflected in the unanimous disposition agreement is a culmination of that investigation and audit of the books. Thank you.
Thank you. Are there any questions from the commissioners?
Judge, this is Commissioner Sylvia.
Okay, let's go ahead and go to the chairman first.
I defer to the chairman.
Thank you. Go ahead,
All right,
Mr. Chairman.
I just have a couple. All right, I just have a couple brief questions. Thank you, Judge. One of them is a technical question. The Water and Sewer Department Field Operation and Tariff Review section on Lake Virginia service area in the second paragraph mentions Lake Virginia and Villa Ridge. Then in paragraph 4 mentions Lake Virginia Ridge system and Lake Virginia system. Is the Lake Virginia Ridge the same system as Villa Ridge, or is that an additional sewer system?
Thank you, Chairman. We're going to get a witness to answer your question from a more technical aspect.
And if the witnesses could introduce themselves for the record and go ahead.
David Spratt, Water and Sewer Department. Lake Virginia and Villa Ridge are separate systems. They were part of the MPB system prior to that.
Okay, thank you. This is again for staff. What is the actual cost of the capital projects completed and included in this rate case?
This is Amanda McMillan with the Auditing Department. That was based on our investigation, and it's basically a black box settlement, so there's no amount that's in rate base for the improvements that have been done since the merger case. We have our own numbers, but none of the numbers for plant and service have been agreed upon.
Chairman, this is Dean Cooper on behalf of Confluence Rivers. I do want to just add one thing that probably was confusing between what I said and what Ms. Payne said in the opening, and that is my number that I referenced was a as of today number. That is not the date that was used for purposes of staff's audit and the rates that have been set in this case, and I'm going to look to the staff to confirm this, but I think that was like a November 12th date, perhaps. And they're shaking their head, yes, yeah. That was essentially what would be the equivalent, I think, of a true-up date in a general rate case.
And if the bench could interrupt, I've forgotten to swear in some witnesses. Mr. Spratt, if you would please say where you are, but raise your right hand. Do you solemnly swear that the testimony you gave and any that you would further give will be the truth in this matter? Thank you, and I did not get your name.
Amanda McMillan.
Amanda McMillan, would you please stay where you are, raise your hand. Do you swear that the testimony you gave and any that you will give in the future in this case will be the truth?
I do.
Thank you. Both witnesses are sworn in, and thank you for all the email reminders. I do appreciate that. I'm feeling a little out of sorts with the procedures of the hearing this morning, so I do appreciate the help. Let's go ahead and go back. Any other commissioner questions from the chairman?
Thank you, Judge. I'll defer to Commissioner Roop at this time, and you're doing a fine job.
Thank you. Commissioner Roop, go ahead.
Great, thank you, Judge. Thank you, Mr. Chair. My question's for staff. So, I understand this case is, under the new self-assisted rate case rule, and we don't have, the testimony and evidence from parties that we typically would have in a normal rate case. I get that. But to that end, the commission issued an order a couple weeks ago, requesting that staff file its auditing department report so as to substantiate the cost of service and rates in this agreement. But staff stated that it considered those documents, confidential settlement documents. But I went back and we reviewed the sections of the staff-assisted rate case rule, and I don't see any prohibition on staff providing its auditor's reports to the commission. So this leads me to my first question, which is, where in the rule does it state that staff's investigation and audit report is a confidential settlement document?
Commissioner, it's not contained in the staff-assisted rate case rule. It is contained in the other rules and statutory provisions that were cited in staff's response. Anytime the parties gather together to discuss what negotiations might reach settlement, as is contemplated by the staff-assisted rate case rule, then that is considered a settlement discussion. The auditing memo specifically was updated in light of the day 120 requirements of the rule that are meant to become a settlement offer for the parties. So unlike the memos that were filed, the water and sewer and the customer experience memos that were attached to the disposition agreement, the auditing memo specifically contained staff's settlement offers to the other parties. And that is why it contained privileged settlement discussion that could not be filed.
Okay, so that being said, I went back and looked at, disposition agreements and stuff before the new rule, and there were past instances that, income statements and EMS runs, containing rate base and cost of service amounts were attached to the disposition agreements. So if the disposition agreement resolves all the issues in the case, what in the new rule prohibits the parties from attaching those supporting documentation and work papers the rule requires to be submitted to the parties when staff proposes a settlement offer?
I can only tell you the legal evaluation that I gave this specific case and that I considered our auditing memo that was provided to the parties in this case.
Okay, let me interrupt.
Well, then that kind of leads into my concern. And my concern is that, at the end of the day, I don't have issues with the consolidation of the rates. Let me just say that, because we've allowed, Missouri American Water Company to consolidate rates. I don't have an issue with that. But I have more of an issue with the lack of information supporting the rate increase and the consolidation. And my concern is there's not enough evidence to support the rate increases and consolidation, given, this is a significant rate increase. So I believe either staff is either A, interpreting the rule way too strictly, or delivery don't want the auditing report attached to the disposition agreement.
I'm sorry, I didn't understand the last.
Commissioner Roop, could you repeat for the court reporter your last sentence?
Sure. Basically, my concern is there's not enough evidence presented to support some of these increases in consolidation, and it's either A, in my opinion, that staff is interpreting this rule way too strictly, or they just don't want the auditing report attached to the disposition agreement. Those are my two concerns.
I apologize, Commissioner. I will point out that subsection 9B of the rule does specifically reference that all supporting documentation for the purposes of settlement is considered confidential. I will also say that if the parties agree, I certainly do not want to be the staff counsel to tell a commissioner no. So if this is a hinging point, with the permission of OPC and the company, we could file it confidentially for the commission's consideration.
Thank you.
I think that would be helpful to us to understand, where some of these numbers came from and how we got there, considering the amount of the increases that we're considering.
Thank you. And Jim Bush has come to offer some testimony. Mr. Bush, please raise your right hand. Do you solemnly swear that the testimony you're about to offer will be the truth?
I do.
Thank you. Please go ahead.
Commissioner Roop and fellow other commissioners, this may not get precisely to the answer you're looking for, but sometimes in other small water and sewer cases where you will see staff file its auditing memo with a disposition agreement is because all the parties agree to the numbers that staff has put forward in their settlement discussion, and that is the numbers that are put forward. In this case, in other cases where we've had a slightly larger company under the small company rule, what staff puts out as a settlement and what is ultimately agreed upon by the parties is not what was in that auditing memo that was submitted as a settlement agreement. Therefore, in this case, not only was it settlement, it doesn't necessarily, we don't have an audit that was updated to reflect the actual numbers that were agreed to by the three parties in this case. So that's other than being settlement, staff doesn't have numbers that could actually support that because we haven't done that level of analysis. It was a black box settlement. So I don't know if that gets to exactly what your concern is, but that gives a little bit more of a history of why sometimes you will see an auditing memo filed with a disposition agreement, and in this case, in other cases, sometimes you will not see staff's auditing memo.
Thank you, Mr.
So, Mr. Bush, help me understand then. So in the past, if everybody's agreed on what's in the memo, then you guys will attach it.
That is
But
correct.
If people, is that correct?
That is correct, Commissioner.
Okay, but if people don't agree, then you don't attach the memo.
Generally, that is correct, yes.
But you have agreed to a settlement offer.
We have agreed to.
And there are numbers that, so could a new audit document be created
I mean,
based off of the settlement numbers?
staff could create an audit based on what we believe the numbers are. I don't know if the company or OPC would necessarily agree to the numbers that we would believe that the certain issues settled out to. And I'll let OPC and the company could chime in as well.
I know.
Yeah, Commissioner, I think that.
And I don't
Go ahead, Commissioner.
proceed.
Commissioner, I
No,
think.
I don't want to. Here's my issue: is I've had issues with black box settlements in major rate cases and small rate cases, and again, it's still difficult for me in my simple mind to get past the fact that we have a stipulation and agreement, and I'm asked to be voting on it. And when I ask for specifics, I'm told, well, all the different parties have different opinions on what the numbers are. And it's just very difficult for me to understand that. And I've just had a growing concern about black box settlements over the last couple of years, and it's starting to rise to the level that I'm extremely concerned. So, Mr. Bush, since you're standing there, if you can dissuade my concerns and you can help calm them, I would appreciate your insight. But if you don't want to tackle that at this time, I understand.
Commissioner, if you would be okay, I would prefer to answer the question. What it is with a black box settlement, the parties come together, and obviously, as in any settlement negotiation, everyone has certain issues that they find to be more of a concern and less of a concern. And certainly, those vary based on the nature of the parties. What a black box settlement does is it gives each party the opportunity to elevate certain issues in their mind to be the more important and perhaps the ones that more dollars are attributed to, as opposed to the issues that might be more important to the other parties. So what it is come to, I mean, certainly we use our starting positions as a foundation for that final number that you see in the disposition agreement. It's just that while staff might consider that certain elements are the ones that more dollars should be attributed to, the company and OPC would attribute those dollars somewhere else. So it's not quite all the smoke and mirrors that it may look like when we file that disposition agreement. It's really just us giving and taking on different issues. But since we can't come to a final dollar amount agreement on that specific issue, we attribute some dollars more to the issue that we find more important. The company attributes those same dollars to an issue that it might find more important.
Yeah, I understand what you're saying, but it's still difficult for us when you have a ratepayer that comes and says, hey, how come my sewer bill is going up this amount? And we have to say, yeah, I don't know, because they all came up with a number, but we don't really know how they're applying their numbers. You ask 3 different people. You ask the Office of Public Counsel, who's supposed to be the person standing up for the ratepayer. They're going to give you a different answer than the staff and then the company. And these black box settlements start to, in my opinion, cause distrust between the ratepayer and the system of which we have, because they can't get specific answers. Commissioners can't get specific answers. And we're told that it's confidential. We can't put that, and we have to push to get stuff included in our record, at least so the commissioners to see, let alone the ratepayers. So it's a transparency issue. It's an issue that I understand you're attempting to work and the rules that you have. I think you're interpreting the rules a little too strictly in this case, but I'm just going to opine on my unhappiness with black box settlements at this point.
On a final note, I would assure you that the parties upheld the type of position that you can certainly consider to be uniform. OPC absolutely argued on behalf of the ratepayers. Staff argued on behalf of the results of its audit and investigation. We did not, by any means, just say, this looks like a good number, let's raise rates to this degree. This number was reached through a lot of hard work and a lot of negotiation and a lot of consideration for what would be rates that would return the cost of service and a reasonable amount of return.
That's all I have, Judge. Thank you.
Thank you. Are there any other commissioner questions? If not,
Judge, this is Commissioner. Oh, I'll wait. My next question is for OPC, so I don't believe they've spoken yet, have they?
no, they have not.
All right, I will withhold until then. Thanks.
Sylvie. That seems like a good segue. Mr. Kleiser, would the Office of the Public Counsel care to make a presentation?
I have no specific comments beyond what has already been said by the other parties. A few things we'd like to point out. A large amount of the costs, as we understand them for this rate case, were primarily driven by the costs of operation and maintenance and payroll. We kind of hope that there are ways that the company might be able to reduce those costs moving forward, especially as they continue, to expand and acquire new systems, that they might be able to find utilities of scale that will be able to reduce those costs.
Thank you, Mr. Kleiser. Are there any questions from the commissioners? Mr. Chairman, I
Thank
think...
you, Judge.
Go ahead.
Yes, thank you. Just a couple. For OPC, what concerns, if any, related to the cost of service did OPC have in this case?
I'm sorry, can you repeat that again really quick?
Yes. What concerns did OPC have, if any, related to the cost of service in this case?
I can say that the OPC had concerns with the inclusion of certain items in rate base, that was a large portion of the part of why there was a black box settlement, because we were able to reach an agreement with the company that they would drop certain issues and we would drop certain issues in turn. We definitely have concerns regarding the overall expense being included for the operation and maintenance of these systems. But like I said, we're hoping that Confluence is able to find utilities of scale moving forward. We'd also particularly like to see them begin bidding out some of the systems which are geographically distant from the remaining, body separately, as we feel like that might be able to reduce costs moving forward. Those were issues, however, that were addressed to the company in settlement negotiations, and we will continue to monitor that issue moving forward.
Is OPC concerned with the rate increase impact on customers that's reached in this settlement?
It's concerning to the extent that it's going to be quite large and it's going to hurt not hurt customers, it's going to hit customers quite hard, but we did the best that we could to lower it to an amount that was just and reasonable.
And I think you kind of touched on this broadly in your first answer, but what led to OPC's agreement on the cost of service and the rates in this case?
We reviewed the audit that was performed by staff. We found that we agreed with most of what they had done. We raised what few issues we had with staff and were able to get some agreements. There were a few issues still lingering from both the OPC and the company's positions. They obviously went in different directions. The OPC would like to have lowered rate base. The company had certain other expenses they think they should have been included. We agreed to essentially mutually exclude those. In other words, we would both drop our countervailing issues in order to reach a middle ground.
Okay, so again, I would like to echo Commissioner Roop's comments a little bit on black box settlements in general and the amount of information we're able to get before being asked to vote on them. But I understand your position. You gave up some things, they gave up some things. All the parties have agreed. So just for the record, does the OPC believe that these rates are just and reasonable for all customers?
Yes. If I may, I'd like to point out two things. I think this was something that's already been echoed by some of the other people, but with regard to the negotiations, there's a lot of risk evaluation that has to go into it. You have to look at how strong the arguments concerning your particular issues are and what the likelihood of success is before this commission. All of that has to go into the calculus you have to perform in determining whether or not to settle. So there are certainly costs that we would like to see not included in rate base, but based on our assumption of the likelihood of success on the merits and other factors, including the likelihood of success on the merits of issues raised by the company, we found that this was the best possible outcome that we believed we could achieve for ratepayers.
Okay, thanks. And just a clarifying question. This revenue requirement, does it only include 15% of the planned updates to the systems?
I'm actually going to defer that to staff. I believe they're better equipped.
Approximately, yes.
Approximately 15%. So then back to OPC, are you concerned at all about what's going to happen in the future when the other 85% needs to be done?
Well, of course we're concerned. I mean, that's going to be an incredibly large increase on customers. But, the answer is, what can you do about that? We're obviously going to examine what improvements are being made, try and determine if those improvements were absolutely necessary, if they were prudent, basically. But absent an engineering analysis and future rate cases, sitting here right now, I can't tell you whether or not those improvements are necessary. That is the problem. I mean, yes, we are concerned. That is a concern.
But even with those concerns, you do believe that this settlement reaches just and reasonable rates for all customers?
I believe that this settlement results in the best outcome that customers can hope to achieve, given the information that I have seen.
Okay, thank you, Judge.
Are there any other commissioner questions? The bench has a couple of questions. And this is going to hit all of the parties. So what is the test period for this rate case? For the record, we have multiple parties looking through paperwork at the moment.
This is Amanda McMillan with staff. The test period was the 12 months ending June 30th, 2019, and updated through September 30th, 2019.
Ms. McMillan, could you please state those dates again? I'm sorry.
Okay, it's the 12 months ending June 30th, 2019, and then updated for known and measurable changes through September 30th, 2019. And then additional improvements for plant going through November 12th.
So to make sure that I have that clear, when you say additional updates for plant, is November 12th then the cutoff date for when you are counting physical assets being used and useful?
Correct.
Okay. And so that's the end date for inclusion of capital projects then?
Correct.
Thank you. And that is where we're getting the 15% number? Okay. Because we're looking at those capital improvements, 85% being still in the future.
Correct.
Okay. And do you know, I'm not sure which party is going to be best for this, the consolidation of the cost of service of the utility systems, is that going to result in a single annual report being filed going forward, presumably for 2020 and going forward?
I would defer to the company.
I'm thinking about what may be kind of layered in your question there, Judge, but yes, Confluence Rivers will file a single annual report, but I think it probably would have filed a single annual report even without this consolidation, as it is the water and sewer corporation.
Okay.
Judge, if it helps, my water and sewer expert is telling me that the company would file a single report. They may break it out by system within that report. It's up to the discretion of the company.
Okay. Let's circle back around to staff's offer, as I understand it, and I want to repeat it so that everyone is on the same page. You had mentioned in response to a commissioner question that there may be a way forward to file the work papers as confidential in this case?
We could file what is the auditing memo that was provided to the parties for the day 120 requirement of the rule, considered to be a settlement offer to the parties, as a confidential document for the benefit of the commissioners. That memo, it should be noted, it would be filed with the caveat that it is not the agreed numbers that went into the final disposition agreement. It's strictly staff's position at day 120.
Okay. And
Your Honor,
yes, Mr. Kleiser.
to that end, and I believe that she's already touched on this, I want to make very clear, the OPC disagrees with certain portions of that report, particularly the rate base. And while I don't want to speak for the company, I believe they disagree with certain portions of that report. I believe it was the expenses, or but I won't speak for them, like I said. We came to a settlement for a host of reasons that I don't want to rehash. And I want to make it clear that we are trying to preserve our legal issues moving forward. If in the future we want to make the arguments that we withheld making in this case because of settlement, we don't want that report to be held against us. We don't want the commission to come back and say, well, you allowed it in this case, why are you changing your opinion? That is part and parcel for why the black box settlement was adopted. I just want to make sure that that's clear and that factors into the bench's consideration.
And I will certainly follow up with, yes, staff would not file it without the permission of the parties because the disposition agreement was reached on the basis that we would not be filing those numbers.
That was going to be part B of that question. Thank you. Would the other parties, Office of the Public Counsel and Confluence Rivers, have any input at this time as to staff's offer to put the auditing memo from day 120 into the confidential record, or into the record as confidential?
Yes, Your Honor. And Mr. Kleiser is correct. I mean, one of the rare instances where he and I have similar views on this process. I think we probably want to go away and talk about your question and get with staff on it. But I think if we go forward, I think at best what this should probably look like is staff's a very clear indication that if an audit is filed, it is staff's and staff's only position as to the underlying numbers. We used to do that at one time with memos from staff in support of stipulations years ago, and probably some of the language that we used to use in that situation would be nice to pull back out, because while we understand the commission's concern and issue, we also, similar to Mr. Kleiser and the Public Counsel, part of the reason that this stipulation makes sense is because it has the ability to preserve some issues for the future if need be. So.
Okay, then let's put a pin in that discussion, and I'll let the parties take that up out of the room. That does lead into another question the bench has, and this is specifically for staff, although I'll invite the other parties to please comment. Staff, you have talked about the 120-day audit memo, and what the bench is looking at is the small utility rate case timeline that is produced in each of these cases. And I believe the rule requires this settlement to be produced by this date. My question is, I'm sorry for the long introduction. My question is, above that, the day 85 case activity says initial audit / investigation reports completed and provided to case manager. Would staff take the position that the day 85 reports are also privileged? And I would follow that up with, at what point are the numbers produced in this area not going to be considered privileged?
I would agree with you that we refer to it as the day 90 pursuant to the subsection 8 F. But what I would say is that staff was still, especially in this case, receiving information in between its day 90 investigation report and the day 120 settlement offer. So while that agreement on its face, no, is not considered settlement, it also does not match the ultimate agreement. We couldn't, in good faith, say that those numbers would be any sort of a basis for the ultimate disposition agreement that was reached.
Is there anything stopping you from filing your day 90, what would you like to call it?
It's the day 90
Memo?
memo.
Okay. Is there anything preventing you from filing the day 90 memo?
Technically, it's considered a starting point for the negotiation for settlement, so I would want to have a consideration before I filed it.
And Mr. Bush has returned to the podium. Please go ahead, Mr. Bush.
If I may, that is more of an internal guideline. Staff does unlike a normal general rate case where the company has filed their testimony and then staff and OPC and any other interveners are allowed to then do their audit and investigation and create their direct testimony. None of that is occurring under the small utility rate case process. It's to help lower the cost. The utilities itself does not do an audit. Now, maybe a larger utility like Confluence, CSWR, maybe they do their own internal audit, but none of that is provided. So what happens when this process is initiated is that the company files a letter requesting that they need some sort of rate relief. Our smaller companies are so unsophisticated. Sometimes it's just a number chosen with no supporting documentation by themselves. So staff undertakes a full and complete audit and has to request information from the company blindly, not knowing exactly why the company has really requested those dollars. So the day 85 and the day 90 is set up so that staff can take all that preliminary accounting and other data that we have, put it in some sort of a brief cost of service and submit it to the parties as this is where we're at right now. Have we missed anything? Is there anything else you want to include? It gives OPC a chance to see where staff is at that time. I think the new rule requires OPC, if they're doing their own audit, to also give that information so that the parties can kind of get an idea of where the case is going, what sort of an increase or potentially decrease, depending on the case, is at that point in time. So it's not even a settlement offer at that stage. It is at best the preliminary results that the commission has been able to gather from the utility at that stage to prepare and to come up with better information over the next 30 days to actually come up with a settlement offer that we can provide to the parties. So that data is very, very raw, and it's just the day 85 is just the case managers need to get all that information to compile it to then send it to the other parties in some sort of a clear manner.
Thank you, Mr. Bush. I'd like to make two quick announcements for those on the phone. If you could please mute your phone. We'll wait for you to unmute it if you're going to speak. And also, the judge's email is down, and this announcement is specifically for the commissioners to please text if you have any further issues you would like to discuss. IT is working on my email currently. I do have a couple other questions, but I do feel that the hearing is winding down. We're probably in the last 5 or 10 minutes. I'd like to switch to the unanimous disposition agreement. Again, if we could have everyone on the phone, please mute their phone. I am looking at I'm trying to get to the residential customer bill comparison. And that appears to be about page 10 of the packet. And I'd like to just look at the percent increases, that column. I'll start my question with a quick introduction. I will have to be relying on this document to write the decision, either way that decision goes. And if everyone could look at the percent increases, please. I don't see that those percent increases match up with the numbers. For example, Auburn Lake Estates has a current rate of $37.50. The proposed rate would be $69.63, which in my non-math attempt is about double, but the percentage says it's 185%. I think that number was gotten to by using the trick on the calculator of multiplying 1 point your percentage. Does staff have any comment on that?
So staff actually prepared, back when we thought that this could be a face-to-face hearing, a updated handout that compares everything. And I would be happy to file that after this. That would probably make things a little bit clearer, and it actually includes more information than the original. I will certainly verify with the parties first, but it should clear things up and reflect what rates would look like and how that came to be based on the agreement.
Thank you. The bench appreciates that. I was also having a little trouble with some of the larger numbers matching up. Let me find where I marked that. Okay. And I don't have the page number. Oh, I'm on page 8. And it is titled Development of Tariffed Rates. And the second line there says agreed upon overall revenue increase, $349,630. However, and the sheet before that has a similar number, 309,666. And when I go back up to the top of the document, it is not matching the numbers at the top, which were 306,555 and 345,597. I'm looking in paragraph 1 on page 2 of 5 of the resolution. And I'm wondering if someone can help me get those numbers to match.
Kurt Gately for staff.
Please raise your right hand. Tell me your name again.
Kurt Gately.
Mr. Gately, do you swear or affirm to tell the truth in the testimony in this case?
I do.
Thank you. Go ahead.
The settlement, the correct numbers are on page 2 of 5 of the settlement document. It appears that the numbers in the attachment are, to some degree, it's rounding, and to some degree, it should have been corrected and updated to match what's in the settlement. This is for demonstration purposes of how we would calculate rates. It's not intended to be the sole representation of the settlement, but we should have corrected that number before we finished it. It's an error.
I will count that. Again, if we could please have everyone on the conference call, please mute their phones. Staff, am I hearing that will also be supplemented in a filing?
We certainly can, yes.
Okay. And then I should take, also on page 2, under number 3, the last sentence, the proposed tariff revisions will bear an effective date of March 12th, 2020. I should file that under this settlement issuing guidance, not necessarily a strict schedule.
That is correct, and the tariffs that were filed by the company, the proposed tariffs do bear the correct effective date.
Okay, and are there any other commissioner questions? The bench is out of questions, and I want to check one last time for any commissioner questions. The bench hears none. Are there any other issues that we need to discuss before we go off the record? Thank you all. The hearing is adjourned. We're off the record.